Hello and welcome to Edukemy's YouTube channel. My name is Harsh Singh, and in this video we shall discuss the feature news for today, that is on right to reproduction. What is the status in India and around the world? What are the issues regarding this? What are the humanitarian grounds on which women are asking for their right? And what are the contentions which have been produced by certain sections of the society? We will understand all the perspectives and what are the legalities as of now. Let's start this discussion. Right to reproduction primarily means that the woman, the person who has conceived the child, should have the decision on whether she wants to reproduce or have a baby in the real world or not. They must, as a couple, must have the right to plan their family. So in case there has been a contraceptive failure, in case the child was not planned, they must have the right to drop the child. They must have the right to awareness in schools or while in colleges on sex education. They must also have right of reproductive health of the highest standard in their country. So these are the kind of rights that every person must be accorded, along with no discrimination, no coercion, and no violence against their own rights. The rights to bodily autonomy, the rights to choice, the right to individual liberty, and the right to privacy. This has been claimed as a right by human activists all around the world. But then rights at times are difficult to find, at times are difficult to fight against the law. And therefore, two perspectives are very important to understand, that the person has autonomy over their body, and the person, if it is a female, there needs to be certain discrimination on the ground, needs to be a positive discrimination on the ground that she must have some individuality and privacy on her own body parts. And this is why people have been seeking rights. My body, my rules. Abortion is normal health care. On the other hand, why is it in news these days is because of a popular Roe versus Wade judgment of the Supreme Court of USA. This is 1973 we are speaking of. Those were the times when abortion was not legally accepted in USA in most of the states. As many as 46 states did regulate or did not call it a legal way to abort a child. And this is where this judgment gave way to all these things and overturned the judgment, saying that a female could abort the child in the first trimester without any condition, in the second trimester with certain conditions, doctor's approval, etc. And see, the primary thing about the judgment was the fetal viability. Fetal viability means the time after which the fetus can survive on mother's womb, inside mother's womb, taking inputs, food, resources from mother, excreting with the help of mother, and the time when the child can be in an independent setup away from the woman. That is the time when fetus can viably survive outside as well. Now this time was the one which would decide what should be the time for aborting a child. The person can abort the child till the time the person is the one which is designated to protect the child, but after the child can take care of itself under artificial aid, the person cannot abort the child. So earlier this time was fixed at around 28 weeks, and when the technology advanced, then people said that child can also survive outside the fetus, outside mother's womb, after 24 weeks of being born, being conceived. So this was the time which was chosen largely as the time after which the person cannot abort the fetus. This is what was in USA, right? So this is the update from USA. But what's the status in India? That is more important to understand, because in USA there has been some update in the Supreme Court, and the judgment might be against, it might be overturned again, and the states might declare abortion as illegal. Let us understand what is the status in India. See, in India, the Indian Penal Code is the one which primarily determines what is the penalty for any crime, and it right away outrightly says that abortion of a child or miscarriage of a child which is done purposefully, voluntarily, it is a crime in India, to the level that the woman who is involved, she also will be held accountable for the same. And there could be penalty, there could be fine, imprisonment, all of them. But an exception was provided to IPC in the year 1971. And please note, although this was quite after independence, but this was before the USA judgment in 1973. India initiated the Medical Termination of Pregnancy Act. So on medical grounds, there is an exception provided for termination of pregnancy. People can access termination of pregnancy on medical grounds. When can they do it? Who can do it? Where? Why? And by whom it can be terminated? All that has been mentioned in the act. So let's quickly understand the intricacies. See, there are quite a few cases under which a person can access this kind of service. One, in case they have grave injury, physical or mental, right? In case they have gone through some bad situations like rape or failure of contraceptives, they can access medical termination of pregnancy. In case they are going through abnormality, or the child might go through any abnormality, or if in the medical opinion of the doctor the abortion must be done to save the mother's life, it must be done. So these are the cases under which abortion can be legally done. Otherwise, it cannot be done. But the time duration in which this can be done has changed for everything. Now, this act was also amended a couple of times. Last time it was amended was in the year 2021, where the gestational age, that means the age of the small child inside the womb, the fetus, that age would change. So earlier there were restrictions which applied after 12 weeks. Now those restrictions will apply up after 20 weeks, right? So up to 20 weeks a female can get the child aborted if one medical practitioner recommends this. And what can be the grounds? The grounds can be rape, failure of contraceptive, and failure of contraceptive ground has been accorded not only to married females now, but legally accorded to the unmarried females as well. So they can access this provided they have a medical opinion of one doctor and autonomy over themselves. If they are over 18 years of age, it is only their written permission. No need to accept any permission from anybody else. So this is as a matter of right for them. And earlier the situation was this, that many people, young people, would get into hassles, and this would also lead to death of those people who have conceived and want to terminate pregnancies in case they are not married. This is a social taboo. So this has been given as a right to young women as well. Now, along with that, if it is up to 20 weeks, no questions asked, but for up to 24 weeks also one can get this abortion done, but only of certain cases of sexual assault, rape, or family issues, minor changes of marital status. In case the woman was married earlier and now she's divorced or unmarried or a widow, so she can get this done only during this situation. If she is ill mentally or physically severely, or if the child is possibly to be severely disabled, in that case she can get this abortion done by seeking the aid of two medical practitioners. Similarly, any lady can get this abortion done beyond 24 weeks only on the ground of fetal abnormality, and also an exceptional situation when her own life is in danger. In that case, no doctor's opinion, only one doctor's opinion is required, and this is only urgent cases, right, which cannot go through such time taking process of consulting two doctors. And in case a person is indulging into divulging information about women, her autonomy, her privacy, then they also will be fined. This is a part of the new amendment that has happened. All right. Okay, so now these rights have been provided in India before what they were provided in many developed countries and America as well. So this seems to be a good step. However, if you see the reality, the termination of pregnancy as a matter of autonomy, as a matter of individual right, that has been questioned because of Indian Penal Code. So these bodily autonomy, when will women get? When will they get their right to decide whether they want to carry the child or drop it, right? So many judgments by Supreme Court itself have very clearly indicated that pregnancy is a matter of privacy and autonomy of body, right to personal liberty, Article 21, right to life and personal liberty. And this has also been reiterated through Puttaswamy judgment of 2017. But the central government, when it was amending the act, it could have included all these features as a part of the Medical Termination of Pregnancy Act, Amendment Act. However, it was not included. Now, this is where there are two perspectives. All right. One perspective is that of the people who are against termination of pregnancy. They say that who are we to take away the lives? We must also protect the unborn child. If you want rights for female, what about the rights of the unborn fetus? And in case they grow up even as a disabled person and they wanted to live, what about their rights? So this is one. Second, who can decide what is abnormality and when it is going to happen? What if abnormality happens at say 35 weeks? Many places one cannot abort the child after 35 weeks. India can, but many places they cannot. Similarly, if one is getting all this thing done, there is also a tendency to understand if the male child is the one which is going to get, produced, or it is a female child. So this kind of biases may also work while we are looking at medical grounds only. This happens in practical reality. Then there are people who question that these kind of tradition of abortion, they have not been a part of the culture of the evolution of humanity. So we cannot have these. Now see, these are the rational or irrational statements which are being made by many people, including politicians around the world. They say that this time frame of for abortion, 20 weeks, 24 weeks, this is very arbitrary, random, and this is error filled judgment. In case this, speaking of Roe versus Wade judgment, error filled judgment, we must overturn this. So conservative speak this. All on the other hand, women and women advocates, they speak that why are you treating women's body as a place for war grounds? Women's body is not a place for war ground. Women's body is meant for autonomy. It is just like an individual's body, and they have the right to choice, right? So while women are also pro-life, they're also while women are pro-life, their personal liberty, personal space is also important. So under these grounds, termination must not happen, right? They also say many of the victims of this kind of penalizing act are young women, women who are in marginalized communities or economically downtrodden, because the ones who have resources and finances, they would easily be able to navigate their way through. But young women who have got a whole life in front of them, people who are from marginalized communities, for example in America, many Afro-American women, and in many in economically downtrodden communities, they go through a situation like this. So we must give women more choice, availability of choice under Article 21. Now these are the various perspectives under which you could look at the right to reproduction. On the other hand, you should be able to also take into holistic accounts the issues present, because there are ethical issues on both the sides: preservation of a new life, unborn life, and preservation of individuals' rights. So be sensitive towards an issue like this, present examples from the world around, and present both the perspective. Now if you like this initiative, share some love through likes, comments, and shares. You got some question, put it down in the comment section. We will ensure to reach back to you. Thank you for participation.